Hello, everyone, and welcome to the 2014 Frankel Lecture. I'm Aaron Bruhl, Associate Professor of Law at the University of Houston Law Center, and I'm honored to be the moderator for this morning's program. Thank you all for coming. Thank you to the University of Houston Law Review for organizing this event, and thank you to the Frankel Family Foundation. Their generous financial support makes this event possible once again. We're honored to have an outstanding presenter and outstanding discussants addressing a timely and important topic. That topic, as you know, is same-sex marriage, about which much more in a moment. First, though, some very brief introductions. Delivering the Frankel Lecture this year is Professor William N. Eskridge, Jr. of the Yale Law School, where he's the Garver Professor of Jurisprudence. Professor Eskridge is, and I think this is not just the bias of a former student speaking here, the nation's leading legal expert in not one but two fields, statutory interpretation on the one hand and sexuality, gender, and the law on the other. He's the author of a number of books and many articles in those fields, among other topics. His case book on legislation and statutory interpretation, originally co-authored with the late Professor Philip Fricke, revitalized the field of statutory interpretation and legislation as the object of serious scholarly study and pedagogical interest. And that book, together with his other early work, set the stage for the next generation of work in those fields. Today, of course, he'll be talking about his other field of expertise, sexuality and sexual orientation and the law. There, Professor Eskridge has, again, of course, written as a scholar, but he's also engaged in popular writing and has engaged the courts through influential amicus briefs. We're truly fortunate to hear from him on this topic of same-sex marriage. Thank you for coming. First, why don't I'm going to introduce all of them first, and then, So our discussants are exactly the people one would dream to have here, and so we're fortunate and honored to have them with us. Nan Hunter is Professor of Law and Dean of Graduate Programs at Georgetown University Law Center. She's the author of a number of books, book chapters, and many articles, notably for present purposes in the field of sexuality and gender, but also in health law as well. Dean Hunter is the author, along with Professor Eskridge, of the trailblazing casebook Sexuality, Gender, and the Law. She too bridges the divide between the theoretical and the practical, the academic and the public, including, among other things, by having authored an amicus brief on behalf of several other leading scholars in the Supreme Court's Windsor decision, which, as you may know, struck down a portion of the Federal Defense of Marriage Act. Before Georgetown, she worked for the American Civil Liberties Union and was the Deputy General Counsel at the U.S. Department of Health and Human Services. Welcome, Dean Hunter. Jane Schachter is the William Nelson Cromwell Professor of Law at Stanford Law School. She's an expert in statutory interpretation, the legislative process, constitutional law generally, and sexual orientation issues more specifically. Like our other speakers today, she's the author of many articles, book chapters, books, and other scholarly works. Much of her recent work, and obviously her comments today, will concern the topic of same-sex marriage, but I can't help but mention that I'm, because of my own interests, deeply familiar with her work in statutory interpretation, and that work is distinguished by its incredible sophistication, and my own work has benefited greatly from close study of her work. Welcome, Professor Schachter.
Thank you.
So, as you may suppose, these introductions could be multiplied over in length many times, but in the interest of time, we'll keep it to that and move on to our topic. So, as I said, this is a very timely topic. Things are moving fast. The number of states allowing same-sex couples to marry is increasing by the week, sometimes by the day. So this is, needless to say, a matter of great practical importance to the many same-sex couples living in states who now find themselves able to marry and enjoy the benefits of marriage from which they were excluded before. But the topic is also one of unusual scholarly and academic interest as a case study in constitutional change and constitutional meaning. In our contemporary legal culture, claims of constitutional meaning generally look backward to a rooting in the original meaning of the document, and doctrinal change often presents itself as redemption rather than redefinition. So at least part of the debate over the legal status of same-sex marriage must therefore be historical in nature, originalist in nature. And so now, without further delay, let us hear from Professor Eskridge on same-sex marriage as a testing ground for original meaning.
Aaron, thank you for that introduction. It's a great pleasure to be here, partly because my students, Aaron Bruhl and Jessica Roberts, adorn your faculty with their brilliant scholarship and fabulous teaching. It was also a pleasure, I can assure the Frankel Foundation, that the Houston Law Review is, I think, the best organized lecture series I've ever encountered. They are professional, brilliant, exceptionally well organized, and on top of everything. So they're great custodians for this important legacy, and I really appreciate the Foundation's support. The topic, as Aaron suggested, is very timely, and indeed I had to revise the lecture after I submitted it to the Law Review because of the breaking developments in the states, and I'm refocusing more of it on Texas because all the eyes are going to be on Texas again. These maps will give you a dramatic evolution of the debate. 20 years ago, this is what the map looked like. The gray states, there's no recognition, and that's the entire United States. 10 years later, the map adds a little bit of color. Massachusetts has recognized marriage equality, and 3 other states have recognized some kind of euphemism, civil unions, domestic partnerships, and reciprocal beneficiaries. But still, the map is largely gray. How much things have changed in the last 10 years? Now, I say tentative map because this is still being worked out in North and South Carolina and some other states. But potentially, there are now 35 states whose circuit courts or their state legislatures or their state courts. This map will show you how we got to marriage equality in the various states. As you see, many of the recent marriage equality moves were by court decision, which have either not been appealed or were appealed through the entire system, and the Supreme Court recently denied review. But the bottom line is almost 35 states now are issuing marriage licenses, and probably 35 states in the near future will be issuing marriage licenses, an idea that was unimaginable. Now, you notice that Texas is still a gray state, okay? But the eyes of the world will be upon Texas, particularly depending upon the Sixth Circuit's review in the DeBoer and other cases that they heard on August 6th, 2014. Any day now, the Sixth Circuit could issue its decision. We think there will probably be a split panel. There's at least one judge who will vote to invalidate all the statutes, at least one judge who will uphold them, and it all rests upon Judge Sutton. If Judge Sutton votes to invalidate, possibly the Supreme Court will deny review again. And then the next case up will probably be the Leyen case here in Texas, which is now on review, where the district judge invalidated Texas's exclusion of lesbian and gay couples from marriage in the provisions that are cited. Now, the decisions that we've already had at the circuit level, which the Fifth Circuit will have in front of it at whatever point it reaches these cases, are very striking. The Fourth, Seventh, Ninth, and 10th Circuits, contrary to Professor Bruhl's admonition that original meaning ought to be relevant, it's pretty much ignored at the circuit court level. And that's very striking. It's striking for me in 3 respects. Reason number 1 is that the Supreme Court, which is at the top of the pyramid, particularly in their gay rights cases, have explicitly invoked history and original meaning. And if the circuit courts are supposed to be applying Supreme Court precedents, which I'm sure they're taking seriously, it is quite surprising to me that they don't take the historical and original meaning arguments more seriously. Moreover, and this deepens the mystery, key justices, and you know I'm thinking of Anthony Kennedy here, who is the 5th justice one way or the other in cases like this, Kennedy consistently relies on original meaning. It was not just a hallmark of his opinion in Romer and Evans, which we'll talk about in a minute, but probably his most famous constitutional opinion is the Birney case, which struck down Congress's use of its Section 5 powers in the the Freedom Restoration of Religion Act. And all 9 justices, in case after case, explicitly consider original meaning and history quite relevant. The Heller gun control case is one example. A recent example is the Noel Canning case, where the Supreme Court evaluated recess appointments by the Obama and prior administrations. So that deepens the mystery, is that there is a huge constituency for original type arguments at the US Supreme Court. And then finally, I think there are excellent reasons for supporters or opponents, as far as I'm concerned, of marriage equality to invoke original meaning kind of arguments. Now let me explain, and I do this at greater length in the Law Review article, exactly what I'm talking about, and I provide some citations for some of the critical commentary when you say original meaning theories and how this is different from original intent theories. Original meaning theories ask what meaning a constitutional text like the 14th Amendment would have had to a neutral reader of the English language at the time of the framing. What did the terms mean as an abstract matter? This approach rejects an approach that focuses only on original intent, namely the subjective expectations of the framers of the text and how they expected the text to apply at the time to specific issues. So, for example, Loving versus Virginia, where the Supreme Court in '67 struck down laws barring different race marriage, which Texas had and Virginia, is very hard to defend under an original intent approach because the framers of the 14th Amendment did not expect anti-miscegenation laws to fall under the equality prong of that amendment. But under an original meaning approach, Stephen Calabresi and others now argue Loving versus Virginia was correctly decided, and I'm going to explain why I think it was correctly decided. I think original meaning has great relevance in the following ways. I think for supporters of marriage equality, of which I am one, original meaning arguments, exactly as Professor Bruhl was suggesting, connect, potentially, traditional American values and American history with the rights of a minority, LGBT, lesbian, gay, bisexual, and transgender individuals, and may help bring closure to the marriage equality debate, because certainly my view is that marriage equality has already won, and that marriage equality in the states that have adopted it up to 35 has not had the ill consequences that defenders of traditional marriage from President Clinton and other adulterers have claimed for it, and instead has had good consequences for the states that have embraced marriage equality. Okay? So I think the debate is closing. And I think history has much to tell us about how the closing debate relates to the ongoing saga of American values. I think this article, which is going to be in the Houston Law Review, also is an important challenge to advocates of original meaning, which includes a lot of public officials, a lot of federal judges, and most of the Supreme Court. And that is, to be blunt, they need to put up or shut up. Original meaning touts itself as the only approach to constitutional interpretation that is objective. In other words, that prevents, at least in some cases, judges from reading their personal values into the Constitution. There is no evidence supporting that proposition. And indeed, there is some evidence suggesting that using original meaning is like looking out over the crowd and picking out your friends. Now, in response, original meaning scholars like Stephen Calabresi have engaged in an energetic campaign to post-justify prior decisions based on original meaning. Oh, Loving versus Virginia. Well, everybody thinks that's correct. So now let's show how it's consistent with original meaning. I think that's fine, and I support that. But here's the challenge. And put this challenge to Greg Abbott and other supporters of original meaning. John Cornyn, your senator. I think he might be on the Judiciary Committee. And that is, if original meaning is anything more than hogwash, it's got to prove itself that it can have bite before an issue is settled. So in other words, original meaning, if it has any bite at all, has got to find an issue, and this should be it, where someone who is not a big fan of marriage equality nonetheless says, I believe the jurisprudence of the Supreme Court and the 14th Amendment and history do persuade me that my views are not constitutionally allowable as state policy, excluding these couples. Now, of course, as we're going to see, I have good arguments, and I think this is a very useful exercise. If people disagree with me, which is quite possible, and in the law review article I give several reasons you might disagree with me, you've got to show it. Okay? Now, let me give you my story. Here's my history story. We start with the framing. What was the normative and linguistic baseline when the Constitution was established in the late 18th century, when the nation was established? And it starts in the article with social contract theory, Hobbes and Locke. And the idea of social contract theory through England and the early colonial history was the idea that the social contract entailed an obligation of generality on the part of the government, that there should be no special classes of citizens. Now, admittedly, the framers had a narrow view of citizenship. It did not include women, it did not include slaves in terms of political citizenship. Set that aside, as objectionable as that is today. For the framers, equality was the baseline for the relevant political community. And that baseline was well reflected in pretty much all of the documents of the founding era. I give you the quotation of one of the less well known of them, but a foundational document, the Virginia Declaration of Rights. It says, and I'm skipping around a little bit in it, because all people are born free and equal, language from the Declaration, and because government, social contract, exists to assure each and every citizen the protections of life, liberty, and property, all laws must be aimed at the common benefit and must be presumptively general in application, with no privileges, no immunities carved out for only a portion of the population. This baseline, which is reflected in most of the state constitutions of that revolutionary era, is then reflected in the Constitution of the United States as well as the Declaration of Independence, particularly in the Bill of Rights, religion, and due process clauses, perhaps also the Takings Clause. The idea was rife in foundational constitutional case law at both the state and the federal level, including Daniel Webster's famous argument in the Dartmouth College case, which rested upon the due process notion of equality and the animus that he located in the due process clause against what was called class legislation. Quoting from an Iowa case, and we have others in the article, laws affecting life, liberty, and property must be general, said the court, in their application, operating on the entire community alike. It is the boast and pride of our institutions that we have no favored classes. The life, liberty, and property of one citizen rest upon the same legal foundation as those of another, and if these are taken from him, it must be by a law which operates upon all alike. Other decisions could be cited for the proposition against class legislation. Now, how does this relate to the language that's actually ultimately in the Constitution of Equal Protection? President Jackson. The Jacksonians, very big publicists for the anti-class legislation idea. And Jackson himself, when he vetoed the bill to recharter the second bank of the United States, said, the reason I'm doing that is that he thinks the bank serves only the interests of rich Eastern financiers and cheats ordinary farmers, merchants, laborers, etc. And in his veto message, quoting from President Jackson, he said, every man is equally entitled to protection by law. Continued. If law would confine itself to equal protection, and as heaven does its rains, shower its favors alike on the high and the low, the rich and the poor, it would be an unqualified blessing. I think it's a sentiment that we would probably endorse today. The principle and the language of equal protection, the animus against class legislation, were embraced in constitutions of new states as well as the common benefit clauses of the old states. The best example is the Ohio Constitution of 1851, which specifically guaranteed all citizens equal protection in haec verba. Now, the focus of the Jacksonians is on economic legislation, legislation favoring the rich over the poor, over the common laborer. Some of the conscious Whigs, the anti-slavery Democrats, the Free Soilers, the early Republicans, increasingly insisted upon attention to social legislation, such as the discrimination against so-called, quote, half-breeds that was struck down in the Reed case. That's the Iowa case I quoted earlier. The classic statement of a new focus on caste legislation, which was considered an extension of the same idea, can be found in an argument by Charles Sumner to the Massachusetts Supreme Court in the very famous case of Roberts versus City of Boston. And I quote it at some length here. You can read it. I'm not going to go through it in great detail. But it's the idea that the class legislation idea also applies to social classes or even social castes. And he uses the example of the caste system in India as a kind of regime which is inadmissible or should be inadmissible under the Constitution of Massachusetts. The language that I find most quote-worthy is the language that tells you what is this obligation and what does this obligation impose upon the government. And I found this very eloquent. And that is, it goes through the list of whatever you are, whether you're poor, weak, humble, black, etc., etc. Again, it's sexist, so he is a man, the equal of all of his fellow men. Then here's the quote. He is one of the children of the state, which like an impartial parent, regards all of its offspring with an equal care. And I think that is an enduring challenge to government, whether it's embodied in the Constitution or not. Now, Sumner's understanding, I argue, is key background for grasping original meaning. In other words, the public meaning that the language of the Constitution in 1868 would have. And indeed, introducing the 14th Amendment, Senator Howard confirmed that the Equal Protection Clause, quote, establishes equality before the law and gives to the humblest, the poorest, and most despised the same rights, same protection before the law that it gives the most powerful. It says the clause abolishes class legislation in the states and does away with the injustice of subjecting one caste of persons to a code not applicable to another. Thomas Cooley, in the most influential treatise written right after the 14th Amendment was ratified, or at about the same time, makes essentially the same point. Though he elaborates, as a law professor would, who's at Michigan, on the idea that, of course, class legislation must impose a discrimination, and the discrimination must not be in the public interest. So that is a limitation. And indeed, after the 14th Amendment, even the southern states that re-entered the Union on kind of forced terms knew that they had to abandon their previous laws prohibiting marriage by people of color. But the states did adopt laws barring marriages between persons of different races. The courts generally, perhaps surprisingly, refused to strike down these laws because the courts believed they treated whites and blacks alike and hence were not discriminations. Once the Supreme Court understood or admitted that these laws were fundamental to a caste legislation, i.e. apartheid, they fell in Loving versus Virginia. And I go through the history of that. Here's the analytic, I think, that is suggested, indeed, I think, required by the original meaning of the Equal Protection Clause. And that is that the clause disapproves state laws or policies that A, discriminate against a person, B, because of acts or traits marking her as a member of a disparaged group, C, without a firm grounding in public need. This is the caste principle. As the articulation suggests, this is a formulation with a dynamic potential. As an exclusion or rule that the legal culture considers natural and public regarding in an earlier time might, in light of experience and new evidence, be revealed as discriminatory and not serving the public interest today. This, by the way, is exactly the case that Judge Bork makes in Tempting of America for the legitimacy of Brown versus Board of Education. Indeed, whether the excluded person is being discriminated against as a member of a class also changes over time. And here's what's interesting. In 1868, there was no social class of gay people, or even of homosexuals. Those terms literally did not exist in 1868, nor did the class. Walt Whitman, America's greatest poet, very probably enjoyed intimate relations with men in the 1860s. But he was a member of no caste nor any social group, and indeed, the law did not even criminalize or discourage his intimacies in 1868. Now that changed after 1890, a generation after the 14th Amendment, when governments increasingly trained their attention on people they called homosexuals, degenerates, and inverts. Between 1921 and 1969, an anti-homosexual terror in states like California, Texas, New York, at the national level as well, created this group, homosexuals let's call them, as a despised caste of outlaws. New laws made oral sex and solicitation crimes. The kind of conduct Whitman engaged in was not a crime in 1868, was a crime in most of the 20th century. New laws categorized these people as sexual psychopaths who, if they were apprehended and diagnosed, could be incarcerated indefinitely and subjected to medical experimentation. These people were excluded from the civil service, from police services, fire departments, military, and from immigration into this country. If they had children, they would sometimes have those children taken away from them. They were denied child custody. Sometimes they were denied inheritance rights under legitimate wills and contracts. These people were excluded from the professions, particularly law and medicine, but even morticians and beauticians by state law. And the state engaged in a relentless and vicious campaign of censorship and even anti-congregation rules regulating their ability to congregate in bars and other places. Now, as I document in the article in excruciating detail, homosexuals and sex perverts, as they were called, were demonized because they were depicted as sterile, therefore selfish, therefore predatory, and therefore anti-family. And the Ohio quote, which is a late quote, I have a lot of earlier ones as well, gives you an idea of the kind of ideology that underlay the anti-homosexual caste system. The Senate Minority Leader in the 50s from the neighboring state of Nebraska, a few states up, you can't hardly separate homosexuals from subversives, he said, suggesting that homosexuality was evidence of communism. The apparatus of the law, therefore, was deployed to entrench the classic stereotype that homosexuals are promiscuous recruiters and corrupters of children and cannot have committed relationships. I might say that these stereotypes were never supported by any evidence, empirical or otherwise, and are widely discredited today. In the last generation, LGBT persons have come out of the closet and protested this caste treatment. And the Supreme Court acknowledged these concerns in Romer versus Evans, which struck down a broad anti-gay constitutional amendment in Colorado. The court started its opinion with original meaning. 1 century ago, Justice Kennedy said, the first Justice Harlan admonished this court that the Constitution neither knows nor tolerates classes among its citizens. That was the famous dissent in Plessy, which I think the dissent was correct as a matter of original meaning. So does Justice Kennedy. Unheeded then, Kennedy continues, these words now are understood to state a commitment to the law's neutrality where the rights of persons are at stake. Original meaning. The court continued with Harris County. That's your case, the Lawrence case, okay? Although Lawrence versus Texas was mainly a due process opinion, Justice Kennedy makes the very important point that when homosexual conduct is made criminal by the law of the state of Texas, that declaration in and of itself is an invitation to subject homosexual persons to discrimination in both the public and private spheres. The President, Bowers and Hardwick, upholding this kind of caste regime, held the court demeans the lives of homosexual persons. Again, about her original meaning. Dissenting in Lawrence, the Harris County case, Justice Scalia predicted that the unconstitutionality of Texas's homosexual conduct law logically required the sweeping away of all anti-gay discriminations, including marriage, which he invoked as a clarion call at the end of his Cassandric opinion. Justice Scalia, ever the prophet, has found his prophecy, much like Cassandra, although I think she was eaten by a serpent after delivering one of her prophecies. So we shall see. But the prophecy, Cassandra's prophecy, is on the verge of coming true in the wake of United States versus Windsor, where he repeats his prophecy with less effect, which invalidated part of DOMA, and which triggered these recent court decisions that have invalidated marriage exclusions from Alaska to Wisconsin to South Carolina to Texas, at least at the district court level. Now, the recent Court of Appeals decisions requiring marriage equality generally apply heightened scrutiny, either because LGBT persons are denied a fundamental right to marry, or because sexual orientation is a suspect classification. Most courts also express dubiety that the state even has a rational basis for the discrimination. Now, I think all this is well and good, and indeed I argued all of this in a book I wrote in 1996 called The Case for Same-Sex Marriage. This is what I argued. But I now think that original meaning can add to this account and suggests that the analysis is much more simple and much more historical. Are the current marriage exclusions part and parcel of a caste regime that the Equal Protection Clause opposes? And I document in my article for the Houston Law Review in detail the caste regime that was assembled in the middle part of the century. And an important continuation of that caste regime is new laws, such as in Texas, that demonize lesbian and gay families. I also argue, however, that the original meaning analysis very much illuminates the debate that is now going on at the Court of Appeals level. And so, for example, a fundamental rights debate. The states tend to argue, and Texas does as well, that homosexual marriage is not grounded in American traditions. It's a novelty, which is true. But that argument is more relevant for due process, which is grounded in fundamental liberties that have a deep tradition in America, than it is in equal protection. Because what original meaning suggests is that the key inquiry for an anti-caste legislation approach is whether the state is excluding an identifiable social group, despised social group, of something important, something legally important, either as a tangible or symbolic matter. And of course, marriage is both. In Texas, you all exclude lesbian and gay people, not just from marriage, but from civil union or a whole range of unidentified recognition of relationships. This is a very broad and denigrating exclusion. And it seems to me this is deeply inconsistent with the anti-caste principle. Moreover, the Supreme Court, consistent, I believe, with the original meaning, said in Turner versus Safely that even when a state disallows prisoners, in other words, convicted murderers and rapists from marrying, that is subject to serious scrutiny, and indeed they struck down the Missouri limitation in Turner and Safely. So if committed lesbian couples raising children are going to be treated in this country with less dignity than convicted murderers, that is deeply inconsistent, in my opinion, with the Equal Protection Clause. What about suspect classification? States deny, and Texas does, that sexual orientation is a suspect classification, mainly because gays have political power now. Now, that's not true in Texas, but the original meaning of the Equal Protection Clause demands that the focus of scrutiny be the legal and systematic denigration of a minority similar to traditional caste regimes, as well as the traditional lack of public justification. In other words, the entrenching of prejudice and stereotypes against a minority group unfairly. That's the core of the anti-caste principle, not ascendant political power. And then finally, rational basis. And I think the opinions have very excellent analysis, including the De Leon case here in Texas. But I think original meaning adds the following deep point to the rational basis analysis. The ideological basis for the anti-homosexual terror was that gays are sterile and anti-family, precisely the reasons still advanced by defenders of marriage in Texas. Attorney General Abbott argues, and this is his main argument, that the benefit of heterosexual marriage comes from its ability to encourage other couples to procreate within a legal union, an end that cannot be achieved in same-sex unions because they do not necessarily result in pregnancy. Now, I commend the Attorney General for this argument. It is a major advance over Bill Clinton's argument that you need to defend marriage against predatory homosexuals. The new argument is not that gays are deranged or horrible, but that straights are irresponsible and kind of wacky. So I commend him, but I don't commend him for endorsing bad stereotypes about heterosexuals. And I think gay rights advocates have stood up time and time again against unfairly stereotyping heterosexuals as irresponsibly procreating. And I urge the Houston Law Review to do the same. Okay? But the point is that the very justification made by the state, which I think is deeply circular, is the following. Because marriage has always been about procreation between straight partners, which is not true, because gay and lesbian couples are not family in the same way, which is not entirely true because they often have biological children, then it remains rational to continue to exclude lesbian and gay couples from literally hundreds of benefits and obligations, and at least in Texas, an indefinite range of contractual relationships that are recognized even in other anti-gay states. What the anti-caste principle gives us is a normative lever against which to evaluate that circularity. When the definition of the institution is the public justification for excluding a social group that has been unjustly discriminated against, it is useful and perhaps fatal to compare the reason for the exclusion to the reason for the caste regime. I conclude with just the following table comparing Loving versus Virginia and the invalidation of anti-miscegenation laws and the same-sex marriage exclusions, such as the ones that are still in place in Texas. And they're eerily similar. I think identical. The effect of anti-miscegenation laws was to reinforce and indeed foundation for apartheid, the compulsory segregation of racial minorities. The marriage exclusion is a foundation for and key to the sexual closet, and that is the compulsory emotional isolation of sexual and gender minorities, including lesbian and gay youth, who are highly vulnerable. The ideology of anti-miscegenation laws, and this has been documented, was the sexualization of racial minorities as morally or genetically degenerate and predatory. Likewise, the exclusion of lesbian and gay couples from marriage is ideologically rooted in the sexualization of gender and sexual minorities as sterile, selfish, morally degenerate, predatory, and in short, anti-family. Justice Powell, in an unpublished draft of his concurring opinion in Bowers and Hardwick, the sodomy case, opened his opinion with, homosexual sodomy is the antithesis of family, which he considered very relevant, and probably was. White supremacy is the ideology of miscegenation laws, compulsory heterosexuality, marriage exclusions. Preservation of the purity of the white race was the, I think, diluted point of miscegenation laws, and in marriage exclusions is the reaffirmation of sexual and gender variation as anti-family, the demonization of that. And the underlying psychological fear, which should not be underestimated, is on the one hand the fear that race coherence will erode and there will be no white race to remain supreme on the miscegenation side. And on the marriage side, I think the deep fear is the fear that gender coherence will erode and families will destabilize. I think that occurs with or without same-sex marriage, and I think rigid gender roles and their decline, which has been the project of the US Supreme Court for 2 generations now, is both inevitable and a good thing. I refer you to the eminent Houston Law Review if you want to know sources, footnotes, and other excruciatingly boring details of this historical account. Thank you.
Thank you very much, Professor Eskridge. Professors Hunter and Schachter will now each deliver 15 minutes of commentary on the lecture, and then Professor Eskridge will come back with a brief response to that, and then we'll have some time for questions and answers.
May I close this down?
Yeah. Okay, so you came in under time. Yes.
Thank you. I want to begin by thanking the Frankel Family Foundation, the University of Houston Law Center, and as Bill said, the extraordinarily well-organized, smart, and fabulous Law Review staff with whom some of us had the pleasure of having dinner last night. I entitled my comments on Bill's lecture, "A Deer in Headlights, the Supreme Court, LGBT Rights, and Equal Protection." And so what I want to do in these comments is to take issue, to some extent, with Bill on basically what I see as the underlying ideology of anti-gay casteness, if one can say that, as well as frame the equal protection debates that the Supreme Court faces today in somewhat different terms. So I begin, of course it's typical in a public speaking situation to begin, or try to begin, with something lighthearted. And so in that spirit, I'm going to quote extensively from the colloquy between Justice Scalia and Ted Olson during oral argument in the California marriage case just about 6 months or so ago. And I think actually it speaks to the trenchantcy of Professor Eskrich's argument about original meaning. So I'll begin with Justice Scalia. I'll leave it to you for the most part to figure out who is speaking what point. Justice Scalia, I'm curious, when did it become unconstitutional to exclude homosexual couples from marriage? 1791? 1868, when the 14th Amendment was adopted? Mr. Olson, may I answer this in the form of a rhetorical question? When did it become unconstitutional to prohibit interracial marriages? When did it become unconstitutional to assign children to separate schools? Justice Scalia, it's an easy question, I think, for that one. At the time that the Equal Protection Clause was adopted, that's absolutely true. But don't give me a question to my question. When do you think it became unconstitutional? Has it always been unconstitutional? When the California Supreme Court faced the decision, I'm going to skip a bit, Justice Scalia, that's not when it became unconstitutional. They did not assign a date to it. I'm not talking about the California Supreme Court. You say it is now unconstitutional, Mr. Olson. Yes. Was it always unconstitutional? Mr. Olson, it was unconstitutional when we as a culture determined that sexual orientation is a characteristic of individuals that they cannot control. Justice Scalia, I see. When did that happen? Mr. Olson, there's no specific date in time. This is an evolutionary cycle. Justice Scalia, well, how am I supposed to decide a case if you can't give me a date when the Constitution changes? 50 years ago, it was okay? Mr. Olson, I can't answer that question. Justice Scalia, I can't either. That's the problem. That's exactly the problem. So I would sort of start by stepping back a moment and observing that the social movement for LGBT equality has led to a remarkable result in which public opinion on a topic that was once thought to be most controversial has shifted dramatically to be supportive of that claim. And my co-commenter, Professor Schachter, is going to expand on that. And in response to these changes, scholars have sought to explain this unique moment with various interpretive theories. One of the most intriguing is the argument that, properly understood, original meaning of the 14th Amendment, indeed 1868, mandates invalidation of laws that exclude same-sex couples from marriage. In my view, the fundamental problem is not the contest about original meaning, but frankly a political one, and that is that the court, since the decision in Roe versus Wade, has been operating almost in reaction to that decision. That is, at least in part, the hesitancy to extend the logic of prior decisions in the area of individual rights and liberties has been constructed, that hesitancy, by the fact that Roe versus Wade thrust the court into the center of partisan politics, which is not a place where the court should be, nor is it a place where the justices feel comfortable. And in a sense, I think of the lecture that Professor Eskridge just gave as being a question of whether we can put this Humpty Dumpty of how to properly interpret equal protection theory back together again. The Scalia-Olson exchange framed an enduring puzzle in constitutionalism, which is how unchanging text most legitimately can accommodate various forms of change, especially changes in the social meanings and moral valence of certain behaviors. There's certainly no more contentious example of that than same-sex marriage. In undertaking a more conventional assessment of how barriers to same-sex marriage must be evaluated under the Equal Protection Clause, courts routinely accept and take it for granted that there has been a long and extensive history of discrimination against lesbians and gay men. And perhaps because this point is uncontested, the judicial understanding of the history is largely undeveloped. No court, for example, has attempted to analyze whether the paradigm of class accurately fits the LGBT experience. As Professor Eskridge stated, and as I go over somewhat in my written commentary as well, the social class, the idea of a social class of gay people, is historically speaking relatively recent. And I would say, however, and this is really where I differ with Professor Eskridge's argument about caste, that it has been developed much more as a function of gender. That is, effeminate men and masculine women became the public face of sodomy and the core of gender-deviant subcultures. As Professor Eskridge has described himself, the anti-gay terror of 1921 to 1969, roughly, began not only with the prosecutions of gays, but also with the era of the new woman, who claimed for herself sexual and reproductive autonomy. Although not perfectly in sync, the evolution of gender norms into somewhat less binary codes in the latter part of the 20th century coincided with the growing toleration of gender deviance and lesbian and gay culture. And in the US, we have seen the law respond to that unevenly, but with a great many advances, as I would say, in civil rights and civil liberties. The central role of gender carries over powerfully into the specific realm of marriage law. First recognized during Phyllis Schlafly's campaign against the Equal Rights Amendment on the ground that its adoption would lead to same-sex marriage, the argument that genderless marriage threatens social stability, and particularly the welfare of children, has fueled the crusade against legalization of gay marriage. As is often true of social panics, it is impossible to distill with any precision which of several tropes reliably produce a level of anxiety that can be most easily mobilized for political contest. Indeed, the relative force of particular arguments may shift over time. I would argue, however, that discomfort over unconventional gender roles has driven anti-gay campaigns at least as powerfully as discussed over specific sexual acts. The foundation of gender in the debates over LGBT rights broadly, and same-sex marriage specifically, complicates the argument that an anti-gay caste underlies the laws that are currently under challenge. Without a plausible account of the degree of social subordination necessitated by the concept of caste, it is difficult to sustain the claim that equal protection's original meaning reaches the particular example. In the marriage context, there are in fact differences between same-sex and different-sex marriages, at least as that pattern exists today. And obviously we are early in the history of same-sex marriage in the United States. But the patterns of difference so far that have emerged turn on division of household labor, sexual contacts outside of marriage, and the likelihood of raising children, all of which are linked in some ways to gender, which is to say that in general, the division of household labor in same-sex couples is more even, although often specific in the sense that division of labor does happen, than it is in different-sex couples. In general, same-sex couples are less likely to be raising children than different-sex couples. And in general, the number of sexual contacts outside of marriage is higher for male couples than for different-sex couples. Those are all general statements. In my view, none of them justifies any distinction in the allowance of marriage for all of the reasons that have been stated. But the gender dynamic, I think, deeply underlines the current debates. And in fact, in recent case law, the argument about genderless marriage has in fact been the leading argument of the opponents of marriage equality. Indeed, I think that a number of the arguments that have been mounted focused on children are actually, although I think they do draw on, in a kind of subconscious way, some of the historical canards about especially male molestation of children, never proven at all with regard to gay men raising families or interacting with children. But I think that the threat that is raised with regard to the welfare of children is often actually the threat that children will be exposed to a different pattern of gender roles than is thought to be common and more typical of the roles that those who are discomfited greatly by changes in gender roles would like to accept. And so my argument with regard to the caste argument is that I think it's important to look more closely at what those caste dynamics are. Again, I think it's impossible to take apart, as in some kind of chemical reaction, the sort of sexuality dynamics and the gender dynamics. Obviously, they're closely related. But in my view, basically what is going on is more of a gender discomfiture. Now, this has turned out to be an interesting pattern among some of the courts that have heard some of these cases. A very recent case this fall in the Ninth Circuit, Judge Berzon concurred in an opinion striking down a marriage exclusion and wrote at some length about the pattern of gender and how it has manifested itself in these cases. And my paper goes on about essentially those sorts of things in some length. But I think that the chief point that I would leave my comments with today is that it's, I applaud actually the invocation, if you will, of the role of ideology in equal protection law. I have some hesitancy about pinning it on a concept of caste because I'm not really sure, although decisions certainly speak at great length about history, I'm not really sure that that can translate into a reliable impact of the sort we would like with regard to caste. It is also true that the current jurisprudence of the court in areas like race leads one to be quite skeptical that if the justices or majority of the justices cannot see caste in the elimination of caste in recent race discrimination cases, as they apparently cannot, it's hard for me to believe that they can be relied upon to properly interpret the dynamics of caste with regard to sexual orientation or other categories. And I close the remarks actually by suggesting that in part what has gone on in these cases, again sort of picking up the theme of the role of ideology and ideas in equal protection law, is a dynamic of a debate, not simply a point-counterpoint debate, but a deeply culturally, socially embedded debate, not only in which people speak, but in which people construct their lives in different ways. And so we are in a moment, I would say, of gender and sexual dissent. And even older than our 14th Amendment, of course, is our First Amendment. Our First Amendment's prohibition on the enforcement by the government of any orthodoxy in ideas or in, I think, ways of being in the way that Justice Kennedy has often spoken. And so I would suggest, in a friendly way to my friend, Bill, that indeed, if the underlying idea here goes back, if we answer Justice Scalia's question, when did this become unconstitutional? The answer might not only be 1868. It might, in fact, be 1791. Thank you.
Thank you very much, Dean Hunter. Professor Schachter.
Well, thank you so much, and one more thank you to the Law Review, the Law Center, and the Franklin Family Foundation for supporting this terrific event, and I'm just delighted to be here. The debate about same-sex marriage has been profoundly shaped by time, and I mean that in two senses. One is we've already seen the marriage map magically fill in over time, over a relatively short period of time. Public opinion, similarly. If you looked at a chart of public opinion, I'll get back to this in a minute, it's a straight line up. So time has made a big difference. But also the concept of time has been prominently featured in the controversy. Consider two central tropes in the marriage debate that have been repeated to the point of cliché. One relates to history, and each side has had its version. The very phrase traditional marriage, used by opponents of change, embeds the sanctity of the past, and references to marriage's asserted history have frequently shaped the oppositional rhetoric. In contrast, those supporting same-sex marriage have commonly responded that opponents of same-sex marriage will find themselves on, quote, the wrong side of history. A second time-related trope relates to the evolution of attitudes about same-sex marriage. Before the president fully declared his support, and then again when he did in a televised interview, he famously referred to his evolving on the issue. And now we are seeing politicians right and left evolving all over the place. It's the new thing to do, evolve. Now, how fitting it seems to me that one of the most publicly salient constitutional debates of our era is steeped in appeals to temporality, given that ideas about time have long also inspired some of the basic battle lines in constitutional law and methodology. Think of it: the history of heterosexual marriage versus contemporary evolution, adaptation to social change, and the call of the future. It sounds not unlike some of the well-worn debates between originalism and living constitutionalism. Now, Professor Eskridge, energetically, always energetically, proposes to upend the structure of this debate, emphatically resisting the idea that originalism in the context of marriage belongs only to the opponents of same-sex rights. And he's given us a lot to think about. As is so often true in debates over constitutional methodology, the ultimate success of his argument, it seems to me, will be bound up with how we frame the relevant inquiry. The Eskridge theory of original meaning gains strength as we, in his words, abstract away from any particular beliefs or intentions that may have been held in 1868. Conversely, the argument becomes a harder sell if we frame the search as one for a more particularized historical understanding about the meaning of equal protection, due process, marriage, or same-sex sexuality as of 1968. And we've seen this theme before in constitutional law. Level of generality is a powerful lever in the realm of both interpretive and doctrinal debates. But in my response to Professor Eskridge's provocative argument, I'd like to look at marriage from the other end of the temporal telescope. The marriage debate has featured a sharp and relatively rapid change in public understandings and attitudes, and the debate has unfolded within the memory of millions of people who can recall, if not when the issue first began to command the headlines when the Hawaii Supreme Court looked like it was going to legalize same-sex marriage, it didn't in 1993, then at least when the Massachusetts court first legalized same-sex marriage in 2004. The issue seems to me to cry out for analysis, not so much of history, but of how the dynamics of recent and rapid change of this sort connect to the enterprise of constitutional law. So I would like to explore the theory of popular constitutionalism in the marriage debate. And some of you, I'm sure, are familiar with popular constitutional. It's the idea that the people themselves ought to play a central role in defining constitutional meaning. It's risen on the scholarly agenda at about the same time as approaches that focus on original public meaning instead of original intention. The phrase is best understood as an umbrella term for a lot of different approaches, but they're connected in the idea that constitutional legitimacy flows not from original meaning, but from support in current popular views about what the Constitution means and protects. And I think exploring it in connection with the marriage debate can yield important insights about both that debate and popular constitutionalism. And I'll suggest that popular constitutionalism works well in this context as a descriptive principle. It has explanatory power. It does not work well as a normative principle. And perhaps we can generalize from that about popular constitutionalism. Now, needless to say, and I want to say this at the top, particularly for those of you who are not familiar with this literature, there are many grounds on which to critique popular constitutionalism, and an obvious question is, who cares what the populace thinks about the Constitution? Aren't courts supposed to be precisely anti-populist or counter-majoritarian when the Constitution demands it? Now, the case has been made by many popular constitutionalists that there is an important component of popular sovereignty that attaches to controlling the meaning of the Constitution, and that the people should not be crowded out by arrogant judicial supremacists. Now, I'm not going to engage the big normative questions. I'm just going to suggest that when we look at it in the context of the marriage debate, we can see a different problem, and it's the problem that I will call the problem of the plural populace. In a nutshell, the marriage debate provides a steady stream of examples of how different populaces can clash and how different people can claim to speak for the populace on matters of constitutional meaning, and it can therefore be quite elusive to identify what the relevant popular understanding of the Constitution and constitutional meaning is on a particular issue. Okay, I want to make 5 basic points. The first one is an easy and obvious one. The polling trajectory on same-sex marriage is dramatic, and it's up, up, up over time. If we look, for example, at Pew polls, it shows that national support has doubled from 27% support to 54% support from 1996 to 2014. And now national polls are regularly showing robust national majorities supporting marriage equality. Moreover, the support is up in every region of the country, although the Pew polls reflect that it is not yet at majority levels of support in the South. Point number 2, before Windsor was decided in June of 2013, most of the states that legalized same-sex marriage had a majority, a plurality, or something close to it supporting marriage equality at the time it was legalized. And that was true whether it was done by a court or by a legislature. There were a few exceptions. I won't go into them here. And this shouldn't be a surprise, right? Because LGBT litigators were strategically picking sympathetic states using only the state constitution to try to keep this away from the Supreme Court. Now, when we look at states that have legalized same-sex marriage since Windsor, when the federal courts have become heavily involved, and 42 of 45 decisions in federal or state courts since Windsor was decided have favored the marriage equality side. It's a stunning turn of events, and I think very few people anticipated that it would be that fast. But when you look at the set of states that have legalized since Windsor, public opinion is much more of a mixed bag. We have many states that now in which a federal court has acted that have a majority supporting marriage equality, but several that don't. Oklahoma, 23%. West Virginia, 26%. Idaho, 38%. I recently read that Robbie Kaplan, the lawyer who represented Edie Windsor, is going to be filing or has already filed a case in Mississippi. I don't know what the polls are there, but I can make an educated guess. Now, it's not surprising that as we get to what LGBT rights litigators call the low equality states, that the polling will change. Many of these states were the same holdout states in Loving versus Virginia, holding on to their ban on interracial marriage, and Lawrence versus Texas, holding on to their sodomy ban. So not a big surprise. Number 3, which populace matters? As we begin to think about these low equality states, the picture comes into focus. In the face of the plural populace, popular constitutionalism does not tell us which populace matters. Is it the national populace that polls show now support marriage equality and even a federal constitutional right to marriage equality? Or is it the state populace in, say, Oklahoma? How, if at all, does federalism enter the calculus of popular constitutionalism? Now, one possible answer to this question is to say that on a national question, like the meaning of the 14th Amendment, national popular opinion ought to trump. This may, I think, have some descriptive purchase, but as a normative matter, popular constitutionalism would appear to have something of a circularity problem here. If in the holdout states, popular opinion supports the idea that whether to have same-sex marriage is a question for states, and does not support the idea the 14th Amendment properly applies to same-sex marriage, then the very question is whether that view ought to be significant. And the present problem of the plural populace has come up before in the context of the marriage debate. Back in 2004, local officials like Mayor Gavin Newsom and others chose to ignore existing law to advance same-sex marriage and use concepts compatible with popular constitutionalism to justify that. Before Windsor, this was also true of the clash between DOMA, which can be seen as an explicit statutory expression of popular constitutionalism at the federal level, and Massachusetts, which decided to allow same-sex couples to marry when popular support was hovering national popular support was hovering in the 30% range. Point 4, who speaks for the populace? Even when we can identify which populace has the relevant view of the Constitution, who will speak for it? The executive, the legislative branch, the populace itself? Well, in many states, right, there's direct democracy, and so the initiative and referenda process can be and has been an important part of the marriage debate. That would be an obvious place to look for popular constitutional will. Now, some popular constitutionalists reject the idea that ballot measures are the best vehicle for popular constitutional sovereignty, worrying about the absence of Madisonian deliberative safeguards and arguing for the virtues of a fuller process of public reasoning, such as in legislative debates. Some, by contrast, have suggested that elected state court judges are the natural vehicles for popular constitutionalism, given that they have to face the voters and are every day deciding questions of state and federal constitutional meaning. Others tout the role of executive officials. Think of the president, think of Attorney General Holder refusing to defend DOMA. And this has become a very common position for AGs and governors around the country to take. It happened in California when Proposition 8 was challenged in federal court. The governor and AG in California refused to defend it. The sponsors of the ballot initiative said, let us come in and speak for the popular constitutional will of the people. And the Supreme Court said, you ballot interveners have no standing to appeal. Only the Attorney General and the governor can do that. Who speaks for the people? We see this right now unfolding in North Carolina, which was the last state to pass an anti-marriage state constitutional amendment in 2012, granted with a small electorate. It was a May election, not a November election, but by 61%, they supported an anti-marriage amendment. 2 years later, marriage equality seems to be coming to North Carolina by virtue of the Fourth Circuit decision, which the Supreme Court denied cert on. Here again, we have the Speaker of the House and the President pro tem of the Senate trying to speak for the people, intervening in litigation. One of those, Tom Tillis, happens to be running for Senate, is speaking against marriage equality. His opponent, the incumbent, Kay Hagan, is speaking for it. Who speaks for the people, right? We have just a morass of possible signals here. Last point, what help can popular constitutionalism give us? I suggest it doesn't work very well as a normative principle. It can't arbitrate between these various kinds of clashes. But I do think it gives us some descriptive guidance. In the early years of the marriage debate after Hawaii in '93, there was a palpable incredulity about the very idea of same-sex marriage. An Alaskan legislator, for example, in the late 1990s, criticized a judge for, quote, attempting to redefine something that's impervious to redefinition. Gravity exists. We cannot eliminate gravity by passing a law. Now, the LGBT side framed this in terms of constitutional rights. And it took a long time for that to have any traction. A lot of people thought it was wacky, right? Over time, as attitudes changed, it became more plausible to say that a right of marriage equality falls within the broad terms of the Equal Protection Clause and the Due Process Clause. Justice Kennedy was quite explicit about all of this in his Windsor opinion, noting that it seems fair to conclude that until recent years, many citizens had not even considered the possibility that two persons of the same sex might aspire to occupy marriage. There can be no more vivid example of this change over time than Judge Richard Posner. And if you haven't read Posner's opinion in the Seventh Circuit marriage case, Baskin versus Bogan, it's an instant classic. Definitely suggest you read it. It has, among other things, the phrase, "go figure," in it. But anyway, in 1992, Posner wrote a book, Sex and Reason, in which he opposed same-sex marriage. And in his opinion in the Baskin case, he took the opposite side of exactly that question, saying that the grounds advanced by Indiana and Wisconsin for their anti-same-sex marriage discriminatory policies are not only conjectural, they're totally implausible. So all of this, it seems to me, is in a literal, not merely an abstract or theoretical sense, living constitutionalism. Many of us as individuals, and we as a nation, have lived living constitutionalism. Thus, I also see what Professor Eskridge in his paper calls a golden opportunity, but it's a different one than he sees. The opportunity I see is to use the palpable dynamics of change on marriage and LGBT equality to emphasize, without apology, how the open textured phrases of the 14th Amendment, equal protection of the law, due process of the law, are and must be given changing meaning over time. Like Professor Eskridge, I see the importance of appealing to Justice Kennedy, but I would not appeal to ideas about original meaning. I see Kennedy as using history in a more diffuse kind of way. And I would underscore what he said in Lawrence. Had those who drew and ratified the due process clauses of the 5th and 14th Amendment known the components of liberty and its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew that times can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. In the end, then, Professor Eskridge and I agree that there are powerful lessons here for constitutional law, but we part company on just what they teach. Thank you.
Let me talk about two different things, one from Professor Hunter and one Professor Schachter, who, by the way, are co-authors on case books, Schachter, Con Law, Hunter, Sexuality, Gender in the Law. And so I guess I should start with Schachter, since Hunter, I require my slide. Schachter, I think, Professor Schachter raises, I think, a couple of different interesting issues. Okay, let's see that. Okay. Let's start with Hunter. Nan raises the question, what is the exact nature of the caste or the ideology we're talking about? And we are co-authors in a casebook called Sexuality, Gender, and the Law. And then says, well, the gay guy says it's about sexuality. Well, I'm a lesbian, I think it's more gender. Well, some of you might remember, some of the older ones, there was a big debate in the 90s, one of the big public debates, it was the certs debate. And a number of Americans fervently believed that certs were a candy mint. Others were sure it was a breath mint. And then there was a wise parent, I don't remember what sex or gender, who would intervene in the squabbling and brightly say, It's a candy mint and a breath mint. It's two mints in one. And I think that's the way sexuality and gender interact. And believe, I think that's the way race and sexuality interacted in Loving versus Virginia. That's the point of my chart. That Loving versus Virginia was not just a case about discrimination based upon the category called race. It was a much deeper case about the whole ideology of apartheid, which at that point was on the run. Apartheid was well on its way to being at least formally dismantled. And Loving was the last major bit in dismantling that formal system of explicit race-based exclusions that were aimed at denigrating a particular race. And I think it was also a deeply sexualized regime, okay? And I think the same is true of lesbian and gay exclusions. I think from the very beginning, and you can trace as an important public moment the Newport naval investigations in Newport, Rhode Island, where there was a hysterical witch hunt, which was both about gender variation, sailors called fairies, who were cross-dressing, effeminate sailors, engaged in sexual intercourse with other men, including the investigators. The investigators actually went through with ejaculation, et cetera, in the course of this, and that caused a bit of a scandal. But it was also sexuality. And the theme of our casebook is that sexuality and gender are in constant dialogue. So it's not a static relationship, it's a constant dialogue. And I think that's the point of the caste system. So caste systems themselves are dynamic. And caste systems themselves might be multidimensional. But they do have a form, and one of the both bad things and good things about law is that law gives you something to organize against and it gives you a target. And therefore it has become an organizing force for both the civil rights movement and the LGBT rights movement to mobilize against explicit legal discriminations. It's much harder for social movements, unfortunately, to mobilize against softer targets. But against these things, I think it's important to fight that, and it's important to defeat them. So I certainly embrace the idea, but reject the possibility that this undermines the concept of caste, because I think this is fundamental to the concept of caste, the mixing of categories. Now, Professor Schachter, I think, poses a couple of different challenges. One is, I don't want to use the term because it would plagiarize my colleague, and I think also Judge Bork. What I'm talking about is living originalism, is that original meaning, by disengaging originalism from original intent, which Scalia and Bork and others did in the mid-1980s, and the slide that gives you that bibliography, they unmoored originalism from this stagnant perspective, and I think made it explicitly dynamic. Those are the articles that give you the exact history of this unmooring. Jack Balkin has written a book called Living Originalism, but the real origin of the idea is Robert Bork in Tempting of America. Robert Bork says that Brown versus Board of Education was correctly decided. That was not correctly decided because the framers of the 14th Amendment expected that segregated schools, et cetera, would be unconstitutional under the amendment they just crafted. Many of them did not. Charles Sumner did, by the way, but many of the others did not, Bork admits. And there's a debate about that. But Bork says, even if that's true, and even, by the way, if Plessy was rightly decided, because remember, Plessy refused to recognize this as a discrimination, creating a caste system. Bork admitted, he said, what we have learned since Plessy is that separate is never equal, and that the legal regime called apartheid was a caste regime that had the effect, and indeed the intended effect, of denigrating a whole class of citizens. And Bork says that was unmistakably true by the time you got to Brown versus Board of Education. And at that point, the court moves. Though notice they don't move against miscegenation laws until 13 years later for exactly the kind of political reasons that Professor Schachter is talking about, okay? So that's the way originalism works. And if you're students and you're interested in this, I do think the debates in Heller, that's the gun control Second Amendment case, I think it was 2008 or thereabouts, and in Noel Canning, that's the decision this year on recess appointments between Justice Breyer, a unanimous court, but fragmented as to rationale, Justice Breyer writing for the majority, opposed by Justice Scalia. Original meaning is about the linkage from past to present. And that's a historical and it's a dialectical process, which is, of course, ongoing. Now, the other thing I do want to explicitly say, I think Professor Schachter and I might be in agreement on this, and that is what role do courts play? Because I think courts actually play a very important role, even if you accept the premises of popular constitutionalism. And I, like Professor Schachter, I do as a descriptive matter, and then we have some. But even if you do as a descriptive matter, I think it's very important to note that the public conversation that occurs is one that is constructed and framed by various actors, not just courts, I agree, but it's constructed and framed. And I think we've seen, particularly since Bayer and Lewin, so going back to when we had no states whatsoever, when we were at the all gray, that was in the wake of Bayer and Lewin, which the Hawaii Supreme Court, ultimately Hawaii did not do same-sex marriage until much more recently. Even Bayer and Lewin, and certainly not to mention Goodridge, which I think was the turning point, Mary Bonato, now a MacArthur scholar, the genuine hero. Forget the stupid books that have been written. The only book is the one where Mary Bonato is the legitimate hero, okay? Because that was the turning point. Now, President Obama gets a lot of credit, Attorney General Holder, for the Cinderella moment of 2011, 2012, which I think closed the victory for us. But here's the role that courts play that I think are very and critically important in framing the debate. So however they define rights, whether it's original meaning or some kind of philosophy or whatnot, the way courts frame rights is absolutely essential, in my opinion. Number one, courts make a big difference as to whether an issue is prominent on the public agenda. No legislature in America was interested in marriage equality in 1993 when the Hawaii Supreme Court upended America. Overnight, though from our point of view, in a bad way, this was on the public agenda. It was on the public agenda for Congress. Now, the effect of that was great overreaching on the part of President Clinton and the Republicans in Congress who gave us DOMA, and the sponsors of initiatives and legislation such as the Texas legislation in 2003, which has a very broad and overly expansive exclusion against lesbian and gay people. Because that actually makes the exclusionary position much weaker when the opponents reveal such a breadth and indeed sometimes a viciousness against this minority group. Because that was Justice Kennedy's first question in Romer and Evans. And that is, this is very unusual for something like this to be passed in America. And the advocate had no answer for that. That was also his question in DOMA. Where have we ever had a federal statute like this degree of breadth, and this degree of denigration of a group based upon such flimsy evidence, okay? So now it depends on the minority group's ability to respond. And I was confident. I was a lawyer in a marriage case in DC in 1990 to 1995. And I was surprised, of course, at the huge reaction and the betrayal on the part of the Democratic Party. But I was very confident then, and I remain confident now, that lesbian and gay couples were no threat to institutions, et cetera, that there were a lot of couples that were committed, a lot of couples raising children, and I might add quite capably. In our family, my sister and her partner raising their 2 children are a model for marriage and for child raising in our family. I think there's a lot to learn. Second, that courts can do, and this was not the case in Bayer, but it was the case in Goodridge. Courts can reverse the burden of political inertia. So a conversation occurs against a backdrop of who must sustain the burden of political inertia to get something done. And before Goodridge, the burden was on the minority group, which was almost impossible to achieve. In Vermont, the court said, you can't exclude lesbian and gay couples from all the rights, and the Vermont legislature responded to that, shifting the burden of inertia in 2000, civil unions law. So we were able to make progress, again, but again, it was important. We had to present our case. We had to show, no, this is not some kind of trick or exercise in political correctness, that we are talking about genuine, real families. And we did successfully. We kept making the same points over and over again. The opponents have changed their arguments almost like changing the linens in the dining room. But we have had the same mantra from the very beginning. These are dignified families that should be treated, by the law anyway, the same as other families, okay? And reversing the burden of political inertia, we got a chance to make our case. This is America. This is not like godless communism. You get a chance to make your case, and even though people might be skeptical, you can keep coming back. And then the third thing, and this is so important, and this is why Mary Bonato genuinely is the hero, is that by winning in Massachusetts and resisting Governor Romney's, I think, very respectful, Governor Romney opposed marriage equality, made very respectful arguments. He was an excellent spokesmodel for the other side. And he lost. Well, that seems to be a recurring theme with him. And then we got marriage equality in Massachusetts. And then there was an election, and none of our people was defeated, and a couple of opponents were defeated. Well, go figure, to paraphrase Judge Posner. And then what Massachusetts did, it offered us, and this is the third thing that courts can do, which is so important, it offers us an opportunity to create conditions for falsification of inaccurate, irresponsible predictions and stereotypes. So it was always irresponsible for Newt Gingrich, Speaker of the House in '96, Robert Dole, wonderful man, very admirable, Majority Leader of the Senate, and Bill Clinton, the President. It was irresponsible of them in 1996 to say that lesbian committed couples raising children were a threat to marriage simpliciter, okay? And not just because they were the three highest ranking adulterers in the United States. It was wrong on the merits, okay? And Massachusetts gave us an opportunity to see that what happens when there is marriage equality, well, what happens is you get happy couples and their in-laws and parents getting grandchildren from their lesbian and gay children whom they thought would never have children on their own. And there were no locusts. There was not a single heterosexual couple who lost heart. There was not a single straight teenager who committed suicide because she was discouraged by gay marriage. And it might have helped some of the hundreds of thousands of gay and lesbian and trans teenagers who are depressed, and some of them suicides. And then we've seen that in state after state. And now we're seeing it in Oklahoma, and we're seeing it in Utah. And to the enormous credit, so I actually don't like the Posner opinion. It's very disrespectful. I think that's not the model. The model is not Richard Posner, who's very brilliant. And I must say, he reviewed my book for same-sex marriage in 1996 very dismissively as well. But that's all right. Converts, St. Paul, Saul of Tarsus taught us converts can be the most zealous. But he's too zealous. He's like too much like St. Paul, who's kind of a zealot. And instead, the model should not be Richard Posner, but should be Gary Herbert, the governor of Utah, said, look, we vigorously and intelligently oppose this. We've lost. And he said, now you marriage license people, you hand out these marriage licenses. This is not a barbarian kingdom. This is the state of Utah. I think one of the top leaders of the Mormon church said, you know, our faith tradition is not on board with this, but I think we should be gracious to our sisters and our brothers who now have this wonderful thing, okay? And so I think that's where we are now. That's why President Obama is very important. I think that's why Gary Herbert is very important. That's why Dick Posner should like shove it and just not, et cetera, et cetera. And I believe original meaning, so I'm not saying in my thing that original meaning is all we should be talking about, but I think that's one of the things we should be talking about. And I think original meaning is a language that we should be engaged in a serious conversation with judicial conservatives, with conservatives all over the country. If they're not persuaded, that's fine. But I do think that this is the kind of language I think we should also be talking to churches, et cetera, that we should be doing in the period, particularly, Professor Schechter, when we are on the winning side, after being on the losing side of the stick for so many decades. It wasn't even worth polling before the 1990s. Okay. A little bit excessively long, but I wasn't under such a time limitation for the response. Thank you, Aaron.
Thank you very much. We now have some time for questions, and the way that you can ask your questions is by coming up to the microphone here.
So thank you so much for coming. This absolutely makes me wish I was still in law school. So I have, perhaps not surprisingly, a question for Professor Eskridge. And I'm wondering if my question is perhaps based in my lack of knowledge about original meaning theory. But it would seem to me that the major shortcoming to thinking of things in terms of original meaning is that the courts themselves has not always adopted these kinds of constructions. And so I think that you argued very persuasively in terms of sort of a general anti-caste reading for equal protection, but the courts themselves have not adopted a general anti-caste reading. They've been specific. Some castes are worse than others, right, in terms of suspectness. And so I'm curious whether or not original meaning gets us far enough in light of the fact that we're still saddled with rational basis review should this come before the Supreme Court.
Okay, I think that's Professor Roberts, as always. She was a brilliant student at the Yale Law School, and actually did one of her student papers on the Ohio anti-marriage amendment in 2004. I think it's very intelligent. Look, I don't think, whatever your theory is, whether it's popular constitutionalism or some kind of fundamental rights theory based upon John Rawls or something based on original meaning, that the methodology, I'll be very radical, we're in a law school sort of format, I don't think methodology makes the difference. I think it really is about the merits of the discussion, okay? And so, you know, original meaning, the anti-caste reading, still leaves hugely important substantive questions ready to be analyzed. So one question is there a discrimination? Now, I don't think that's such a huge question in the marriage equality cases, but it did bollocks up people in the 19th and early 20th centuries on the anti-miscegenation laws. You know, some of them probably quite honestly. And by the way, I might also add in Plessy versus Ferguson, you know, Justice Harlan saw through this, but I think he might have been the only justice from the South. I think having Southern justices is a huge advantage for a court. And I condemn Congress for pitching a fit when Harriet Miers of Houston was nominated to be on the court. Because she was both a commercial lawyer, which I think the court really could use that, and she's from Texas. And I think she would have been a great appointment, and that she was not shut down by the Democrats. So, yeah, she's shut down by her own party. It was like fragging your commanding officer or the lieutenant. So I think these are, and then the question of state justification. To make a determination this is a caste, let me be very serious about this, is you're making a substantive determination. Because it is certainly true, and this is where a lot of, Nan, this really is where a lot of the lesbian and gay animus comes from. The 1940s in California, Earl Warren presided over the most vicious anti-gay culture conf in North American history. Earl Warren, liberal governor of California. And one of the triggers that produced a ton of anti-gay legislation by Governor Warren and his legislature, though he had done a lot before, was the murder of Linda Glukoft. She was picked up, molested, and murdered by an elderly man who was the neighbor. Okay? Now, this vicious murder created a hysteria in California that they needed to do something about child molesters. Now, as the Glukoff case itself reflects, the overwhelming amount of child molestation is done by older or adult men against girls and adolescent women, overwhelmingly. And in California, that was the case as well. But the statutes that were passed, you know, allegedly targeting child molesters, brought in their ambit lesbians and gay men. Okay? Now, child molesters could be viewed as a class. They're subject to criminal penalties and all sorts of penalties afterwards. But it's not caste legislation, because there the state is performing its Hobbesian function of protecting among the most vulnerable of us. And indeed, the main criticism against child molestation laws is they're not very effective. And indeed, one of the many prices of the anti-homosexual terror in the 20s, 30s, 40s, 50s, and 60s was that the obsessive focus on lesbians and gay men, most of whom were involved in adult consensual relationships or hookups, was that it took attention away from fathers, stepfathers, boyfriends, uncles, and grandfathers, including in my own family, who were molesting female youth in their own family. And we now know Catholic priests who were mainly molesting young boys, but sometimes young girls. So the focus on adult, sometimes long-term committed relationships was insane from the point of view of, apartheid was insane from the point of view of society as a whole. The South has been liberated by Brown and Loving from its worst, drawbacks, some of its worst drawbacks. So when you talk about caste, you cannot be facile. And that's why I denounce judicial decisions that ignore the history. I think I think the decisions are very nicely reasoned, et cetera. They're all very serious. But I think somebody needed to write an opinion. Maybe it'll be the Fifth Circuit. Maybe there'll be a dissent going my way and a majority going against me. But both of them engage in the history. Was this a caste regime? Was this fair to gays and lesbians? Was it based upon real sort of social contract concerns, or was it based upon hysteria and stereotypes and bad policy? And you learn that by looking at it over time. That's the other point of history, is you read the history and you deeply understand where the sentiments are coming from that produced the 2003 Texas law that not only says you can't recognize their marriages, but also civil unions and other contractual relationships. It's very elliptical, okay? And I think that's very important. Just as in the race cases, I think we have an amnesia in the race cases about understanding that history continues to have ripple effects. And the idea of a caste doesn't end just simply because the laws end. So there's a broader project involved here. And I think all three of us would say it's got to be substantive. And it's got to be on the merits. And I think, whatever you want to label it, this is an ongoing public conversation about rights, the dignification of citizens or not. And indeed, as Professor Hunter suggests, here's a hot tip. And that is that the proponents of DOMA did have this right. And that is that the marriage equality debate does have implications for our polity's construction. So again, Jessica, it's a framed debate. Our polity's construction of what marriage is. And so as Professor Hunter has argued, there will be implications of marriage equality for undermining further the gendered nature of marriage. And I will say this finally, that maybe the root, what combines the Hunter points with mine, is the idea of complementarity. Is a lot of the opponents of same-sex marriage, and these are honest opponents, these are not necessarily bigots, believe deeply in the idea of complementarity. That the male and the female are yin and yang, their sexual organs fit into one another in ways that are generative of the species, and that this is naturally a good thing that needs to be preserved. And indeed, I think for many people, same-sex marriage is still unintelligible because it so deeply violates the idea of complementarity as the foundation for society. And so one of the points of, I think, Professor Hunter's critique is that feminism has long been attacking, either directly or indirectly, this idea of complementarity as so essential. And that's where lesbian and gay people come in as well with marriage equality, hence the Berzon concurrence and others.
Could I just comment for a moment?
Very generative question.
Yes. I mean, I think that the interaction here raises some really fascinating questions, many fascinating questions. One of which is how a dynamic of caste can operate in law, and we've already seen I think the courts fail the test of understanding. The contemporary courts fail the test of understanding the meaning of caste in the situation of race because they've gone backwards. But I very much agree with Bill that there's a complex dynamic going on. It's a dynamic of racialization and sexualization. And so that in the Loving case, I would argue that if one had to identify a caste, it indeed was the caste of race and of apartheid. But unquestionably, that racial caste system was deeply, deeply sexualized. And I think that so you have something that is intrinsically a process, I think, and a dynamic, and something that is indeed quite multidimensional. But I think it's also important to distinguish caste from panic, because there have been a lot of occasions in our history where there have been social panics about one thing or another. I suppose, Ebola may qualify at the moment, but you can think about anti-communist hysteria and any number of other things that don't, fit into a conceptualization that goes, I think, as far and as deeply as caste. So arguments might fit into an equal protection theory, and I would say, should result in a rectification of one thing or another, perhaps, along the lines of an equal protection theory. That's quite possible, but nonetheless not reach what I would think of as being sort of a full caste. And my last point is that I think that the law itself and its necessity, its sort of logic, its conceptual, sort of deep structure of law and legal arguments has almost an inevitable reductive effect. So that, sort of, is it this form or is it that form? Is it this ideology? Is it that ideology? I agree with Bill and with the title of our casebook that it's both. It's a fundamentally layered structure of oppression in this particular instance and in others as well. And so I think one of the problems is that the anti-caste principle, which a number of others have talked about as well, in some ways I agree very much with the principle and with the idea that it animated the adoption of the 14th Amendment. I mean, there's no disagreement there. But the sort of probing into what all of that dynamic framing and reframing and construction and reconstruction has involved, I think is really a enormously difficult intellectual project.
I, of course, also have to chime in. The question, I think, raises, for me, an interesting issue, which is what are the implications going forward for equal protection of casting theories and ideas more in originalist terms. So let me just say from the outset, I am not an originalist, living, dead, or otherwise. And I think that as originalism gets more dynamic, it becomes harder to distinguish from old-fashioned living constitutionalism, or what David Strauss calls common law constitutionalism, which is really kind of an eclectic approach, which of course looks at history, but also looks at consequences, looks at text, looks at doctrine, I love the anti-caste principle. I'm all for it. Put me down. But not as a matter of original meaning, because I worry. It's such a manipulable methodology. I like the way Bill uses it, but I think that's not the way it can be used and is often used. It's really much more kind of in the hands of, say, Justice Scalia. It's an appeal to leave more things to the political process, the ordinary political process, and have fewer things be dealt with at the level of the Constitution because, because of ideas of original meaning. Now, what I do think is, so I'm a skeptic, and I think it's ultimately manipulable. What I do think is interesting is that, people will say about the Brown v. Board case that if you have a decent constitutional theory, it has to be able to produce Brown. And so originalists came somewhat late to the party, but with Judge Bork and with my colleague, Professor Michael McConnell, made the case for an originalist reading of Brown. And I think someday that may be true of Windsor. I'm not sure for many originalists it's true today, but I think it will be perhaps true of Windsor. You have to be able to produce Windsor. And in that case, they'll whip out their Houston Law Review, and Bill will have given them the roadmap.
Well, to return to our theme of history and time, I think our time together this morning is drawn to a close. Our speakers will be here for other questions that members of the audience may have. I hope to see many of you here again next year, and please join me in thanking our speakers.